Assalamu alaikum, I'm Carl Arrindell and you're watching In Focus. Now, Air Force Captain Michael Schwartz and some of his fellow US attorneys managed to grab the international headlines last year. Between them, they were representing a number of high-profile Guantánamo detainees during a trial before the Guantánamo Military Commission in 2012. The more famous of these clients included Waleed bin Attash and Khalid Sheikh Mohammed. Their clients stand accused of involvement in the September 11 attacks in America. I'm pleased that Captain Schwartz has been able to fight off a bout of our own epidemic neurovirus on the weekend to join me here in the studio in London today. Captain Schwartz, Assalamu alaikum, welcome to Islam Channel.
Carl, thank you very much for having me on.
Now, last year in October, during an arraignment hearing, you were, I understand, publicly berated by the judge, Army Colonel James Pole, for daring to offer an explanation as to why your client, Khalid Sheikh Mohammed, objected to wearing headphones during the proceedings, which had been provided to give Arab-English translations. Can you explain what the fuss was about?
I can. The incident, and first I'll qualify. My client is Waleed bin Attash.
Yes.
Mr. Mohammed is one of the other four co-defendants in the case. My client, on the morning of the arraignment, this was back in May 2012, was wheeled into the courtroom against his will, strapped actually to a chair. And he sat that way for almost an hour. After about an hour, the judge was convinced that he was able to remain in the courtroom unrestrained and agreed to remove the restraints. At about that time in the morning, we had a discussion about the fact that my client, Mr. bin Attash, was not able to wear the headphones that were provided by the court. The courtroom is set up, it's an enormous hangar of a building. It's probably 30 meters square, approximately, give or take. And each client has his own table for his defense team. And over the public address system, they can pump out what's a simultaneous translation of everything that's happening in the courtroom in English. But that becomes disturbing most of the time. So they tend to do it over a closed feed so that the clients can wear and hear through headphones the Arabic translation of what's going on. Shortly after the beginning of the hearing that morning, my client was, I'll just say, unable to continue to wear the headphones that were provided by the court. And there was a short colloquy between the judge and myself about why that was. And as part of the explanation, I simply said that my client, who had been subjected to torture by the United States, and at that point, everything stopped. The reason that I said he had been subjected to torture was simply that that is the only thing I'm allowed to say with respect to what happened to my client in the custody of the United States. Any details beyond that about specific enhanced interrogation tactics, as they say, specific torture, is simply classified. If I say it, I end up being prosecuted. I am allowed to say that he was tortured, and he was. At the moment that I said that, the courtroom stopped. Up on the judge's, we call it the judge's bench. He sits behind the high bench that I think most people are familiar with off of TV and movies, is a flashing red light. Kind of looks like what you'd find on the top of an old police car. A light starts flashing, and there's a 40-second delay for the audio that's fed back into the viewing area of the courtroom. It's actually outside of the courtroom, so there's a 40-second delay on that transcript. That gets cut. So for the next 40 seconds, we had to sit in silence while this red light is spinning, and the judge seemed not particularly happy about what was going on. And at the end of the 40 seconds, he looked at me, and this is at that point, we're off the record, and he says to me, essentially, Captain Schwartz, you know better than to say that. You know where the lines are. You're crossing the line. And I and the other four defense attorneys sitting at the tables at that point were completely shocked, because as much confusion as there is about what is classified and what is not classified, we knew that what I had just said was absolutely not classified. And so for me to be reprimanded based on saying that was honestly terrifying. 4 days later, I think it was, we found out that the Pentagon had decided to release the full transcript because what I had said was not classified and there was no problem with it. But it goes to show that you can't get too close to embarrassing the government with respect to what happened to my client, or you'll have something shoved in your mouth.
Now, I have to say, it's a bit shocking to hear that that's going on in our courts. I mean, it's taking profanity buttons to a new level. On this issue of secret evidence, I understand that you've made representations to the judge to seek the abolition of what they call presumptive classification. The process, as it's called, the judge that treats top national secrets any discussion of what happened to the defendants during their time in CIA custody. There have also been requests for limiting the closure of the court to news organisations of what they call secret sessions. Now, have there been any concessions granted in this regard, and what are the implications in terms of justice for the continuation of this secrecy policy as far as you're concerned?
We have not had anything favourably granted on those two issues yet to date. With respect to presumptive classification, it's a far broader problem than it's made out to be, I think. If you're going to say that we can't talk about what happened when our client was, first of all, he's been held in custody since 2003, custody of the United States. But between 2003 and 2006, he was disappeared. I can't tell you where he was. Nobody is allowed.
Even if you knew?
If I knew, I would not be able to tell you where he was. And so far, we've not been given any evidence, any discovery from the prosecution with regards to where he actually was. But presumptive classification presents something that's, I think, it's not, in my opinion, it's just far more comprehensive. If my client told me that he was hungry and wanted a turkey sandwich for lunch, I couldn't tell you that because it's presumed to be classified until there can be some sort of review done. Now, we haven't been able to figure out what kind of review that is and how to actually achieve that review. But in effect, I just can't repeat anything my client says, ever, until that changes. Anytime he opens his mouth, he is presumed to be saying things that are classified, whether it's his own thoughts and interpretations for how he's feeling at that moment, or whether it's in respect to what happened to him in U.S. custody. So obviously that's problematic for a defense attorney not to be able to repeat the statements of his clients. What's interesting is, I mean, obviously that's just prohibitive for any kind of conversation, for any process at all. So when we got into court on the morning of the arraignment, the judge began to ask questions of the defendants, questions like, can you tell me your name? The normal colloquy that you have at an arraignment where the charges are read to you and you're forced to answer, how do you plead? It's still unclear to me how it is that our clients are able to go into the courtroom and talk and speak to the judge, speak to anybody in the courtroom, anybody who's watching at the 4 or 5 locations on the East Coast of the United States in movie theaters where they send a broadcast of the proceedings. So the client's allowed to talk when the government is ready to hear him speak. I just can't repeat anything that he tells me.
So, in effect, the process is about trying to tie the hands of his defence attorneys rather than limiting national secrets.
I don't doubt that the purpose at some level is to protect national secrets, if there are national secrets involved here. I question that, honestly. But there's no question, at every step of this process, my hands have been tied, logistically and legally.
I need to just understand something here. Who decides when something your client has uttered is admissible or to be used or can be used? Or is it never discussed?
Well, it's 2 separate questions. First, if somebody has what's called classified information, that information is owned by what they call the original classification authority. Okay? So whether it's classified or not is a separate question from whether it's admissible. The classification authority decides if something is classified. The judge decides whether it's admissible. So it's completely fair for the judge to say, here's a piece of evidence, and I'm going to let it be said in this courtroom, or I'm not going to let it be said in this courtroom. But he has no authority to make a decision as to whether something actually is classified, because only the classification authority can do that. We've only recently learned who the classification authority is in this case. For a long time, we were operating without that information. What's even more shocking is the fact that the classification authorities in this case, it turns out there are multiples, might not have been, well, I shouldn't say might not, simply have not been following the law with respect to classification. So there's a legal argument right now that actually nothing in this case is classified because they haven't been following the proper procedure.
It gets more and more strange the more you tell us. I'm going to come back in a moment to this, but I have to say I was sorry to hear that your colleague, attorney Cheryl Borman, who I'd hoped would be joining us today, has been overwhelmed and is still indisposed as a result of our UK neurovirus. Do pass on my best wishes and my hopes that she'll recover quickly from that.
Thank you.
Now, I remember reading the headlines in a UK tabloid newspaper, the Daily Mail, in which Cheryl was described thus: an American female defence lawyer covers up in traditional Islamic dress out of the need to respect her client. I think that was Attash. Religious beliefs. The decision of Cheryl Borman seemed to upset a number of the families of the 9/11 victims represented by the prosecution. There was also some disquiet about the request of some of the accused to make prayer in the courtroom. I remember seeing animated sketches of 5 of them praying in the middle of the court. Can you give us a feel of the atmosphere in a court and to what degree you may have anticipated the degree of upset that caused?
Sure. I read the same articles that you did. In fact, I walked out of the courtroom that day to the press conference that follows each hearing, and a press contact that we have came up to me and immediately said, you need to be prepared to take questions on what Cheryl wore to court today, because there are a lot of people who are disappointed about it. And it turned out to be a lot of Americans, a lot of people around the world, a lot of Muslims were offended by it. Cheryl certainly meant no offense by what she wears in the courtroom today still. We as a team meant no offense by supporting her decision to do that. She wears an abaya to court, and she wears an abaya always, at all times, in the presence of the client, out of respect for him, to help him participate in the defense of his life. So ever since, I believe it was the first meeting, October 2011, that Cheryl and I had with our client, she wore a suit to that meeting like she would normally wear it to a client visit. Without repeating what the client said, from the next visit on, she has worn something that covers her from wrist to ankle. And it is what it is, and it will continue to be that way until the client, for some reason, if he changes his mind, if he decides that he doesn't want her to wear that, maybe that will change. I don't know. With respect to praying in the courtroom, honestly, I believe that was a decision made by the judge. Our client prays 5 times a day, wherever he is. And normally that happens either in his cell or in a meeting room if we happen to be meeting on that day. When they're in court, the process for getting them from where they live into the courtroom is arduous. It takes a long time. To get them back just for a lunch break so that they can pray in their cell makes no sense. And so for the judge, it just made more sense for him to say on that day, we're going to have prayer in here. He was respectful to stop at the prayer time. But
it didn't clear the court.
It did not clear the courtroom. So the back of the courtroom, the families, I guess, maybe still could have been in there to see it. It sounds like they were. I was in there to see it. I can tell you, I don't know if it was arraignment or at the hearings that followed that, but Ramzi bin al-Sheba tends to be the one who calls the prayer, and it's one of the most beautiful things you've ever heard, his prayer call. You can understand that maybe some of the families who might have drawn conclusions about the guilt of these defendants before the trial has started might not be considerate of religious preferences, which to me is disappointing, living in a country that's founded on religious freedom and respect for each other's religion. But it is what it is. Now,
I have to say, listening to what you've said so far, it sounds something out of a sort of Kafkaesque novel. We seem to be now living in a world in which I think the phrase known unknowns language used by former Defence Secretary Rumsfeld has become the norm, where detainees have no legal status and are subjected to a legal black hole in which almost anything goes. Do you accept that that's the situation these days?
I would fully agree. I don't accept the situation, but yes, that's well stated. The decision to hold these hearings, the decision to confine these men in Guantánamo Bay from the beginning, I think has been an attempt to remove them from the law. And so what you have now is a United States court, a federal court of the United States of America, being held outside what they say is the jurisdictional limit of the United States, and therefore maybe the Constitution of the United States does not apply. And as a result, we filed a motion recently suggesting that the judge come to the conclusion, before we even start, that the Constitution does apply. We haven't won that motion yet. And to me, the suggestion that any United States courtroom would not be following the Constitution, I know that's an overgeneralization of the issue, but it's a little bit disappointing, especially in a criminal prosecution.
Now, talking about the Constitution, the Military Commission's scheme, as was established by President George W. Bush in 2001, a mechanism that was defined to process and try individuals suspected of involvement in terrorist acts or offences committed during armed conflict, it's garnered considerable national and international controversy. And upon taking office in 2008, President Obama signed an executive order requiring the closure of the detention centre at the US base in Guantánamo Bay in Cuba within a year. He also indicated that there would be an exploration of other methods to ensure fair trials for the detainees. Yet most of those plans seem to have been relinquished, and we now have a system which has been dubbed due process exceptionalism. Wonderful language. In your opinion, can the detainees, your clients, expect to have a fair trial? Can you perhaps, without compromising you or your client's legal position, give us some indication of the legal nature of these trials, sort of start, beginning and prospective end?
Certainly. I can tell you my client is a thoughtful, reasonable person, and he will be patient and give if the jurisdiction, if the process shows itself to be true and fair and transparent. I believe that he will give it the opportunity to judge him based on these charges. I think that if we look back to 2001, we have seen what has just been an incremental failure that at this point really has just become an embarrassing process in the military commissions. We had the first prosecution that reached the Supreme Court in Hamdan that was reversed because we weren't following a number of required procedures. The result of that was the passing of the 2006 Military Commissions Act. That process also failed. We have prosecutions after that for material support for terrorism that recently was overturned. And so now, even though on our charge sheet we never saw material support for terrorism, nobody will be charged with material support for terrorism again, because that's something that simply shouldn't be charged in this jurisdiction. Last week, you might have heard that the prosecution is now recommending that conspiracy as a charge be withdrawn from this case. And that hasn't happened yet, but it's safe to assume that will happen. What that means is, on the 20 pages of charges that exist in this case, we're going to be left with 3 pages. The first 17 pages of the charge sheet will be withdrawn. From the beginning, we were not prepared. This jurisdiction was not prepared to try this case. And we continue to see that every week.
Now, I understand that Mohammed and Aziz Ali, defendants Ramzi bin al-Shib, Mustafa al-Hawsawi and Waleed bin Attash, have been charged with conspiring with al-Qaeda, attacking civilians and civilian targets, murder in violation of the laws of war, destruction of property, hijacking and terrorism. All 5 could face the death penalty if convicted. There was an attempt to try them initially, wasn't there, at Guantánamo Bay, which ended when the Obama administration tried to move all the trials to New York City. That was abandoned, again, under pressure from Congress and New Yorkers, and the charges were refiled in Guantánamo Bay. There's been a bit of a toing and throwing. But it seemed to me that there was an initial attempt at a progressive process, a trial in a federal court. That was, I think, the intention that Obama tried to at least infer. Was that, in your opinion, a progressive move, and what are the implications of its failure?
I can't disagree that moving from Guantánamo Bay into federal courts would be a progressive move. The federal court system in the United States is one of the most respected criminal courts in the world, in the history of the world. It has successfully prosecuted, and when I say prosecuted, it might result in a conviction, it might result in an acquittal, but you have successful prosecutions in hundreds. I believe it's somewhere between 250 and 300 individuals in the Southern District of New York and the Eastern District of Virginia. Guantanamo Bay does not have that history. There is no precedent, there is no case law, there are no stories of success. There's nothing for practitioners to look to say, this is how we operate in this jurisdiction. It's simply a mashup of some federal rules, some military rules, that when put together, nobody can interpret and nobody knows how to employ. So yes, I think there was a bit of a noble attempt to move to federal courts, but the political process seemed to get in the way. President Obama, despite his claim during his campaign and immediately after his inauguration, simply failed to move successfully to the federal court system. And I don't know what the future holds. I don't spend much time on Capitol Hill. It happens to be where I live, but I don't engage in that process. I spend quite a bit of my time in Guantanamo Bay. We'll see, but there seems to be no question at this point that the United States Congress is not ready to allow these 5 defendants to be tried anywhere other than Guantanamo Bay, or at least if it's in another physical location under any other system than the military commission system. And I think what we're going to see is that that's just not feasible.
Will there be a show trial? Do you think that they will try and find a way to force a pre-prescribed result, or is this just going to be marking time?
I think there can be an effort for a show trial, but only for so long, because when the system continues to unravel the way it has with the recent material support for terrorism charge being overturned, the conspiracy charge being withdrawn, at some point it's not a very successful show trial if everything that the prosecution does turns out to break.
Now, the US seems to be increasingly moving away from international protocols. So despite its reputation as one of the leading legal authorities worldwide, there's been a dismissal of certain components, at least, of the Geneva Conventions openly by senior figures, especially as it relates to torture. What, in your opinion, are the implications of the continued use of torture and of evidence gained by torture?
The implications are a few. First of all, evidence obtained by torture is unreliable. The criminal justice system in the United States is designed to achieve the truth, to know what the truth is. When you are interrogating or employing any manner of torture and then using any evidence that results from that, you find yourself working with unreliable information. There's a strong argument that the invasion of Iraq was improperly premised on torture of a former, it wasn't Guantánamo detainee, but Egyptian, and I don't want to falsely accuse any other nations of the cooperation in that torture, but what led to Colin Powell going to the United Nations and saying that we know about weapons of mass destruction. And we all know what that led to.
Apart from the sexed up dossier, that is.
Yeah, correct. So, yeah, to answer your question, I think that the United States is now beginning to look back, and the world is now beginning to look back at this possibly being some of the darkest moments in American, not to say foreign policy, but policy of any kind. The use of torture is inexcusable in any circumstances. That's something that we have prided ourselves on, both as a military and a nation, for a long time, and the failure to abide by that belief and that principle is something that will haunt us going forward.
Well, I have to say it's been, I suppose, eye-opening, shocking, enlightening to hear what you have to say. I think that we have to just commend you for the work that you continue to do. I know under very difficult conditions. Captain Michael Schwartz, thank you very much for joining us on Islam Channel.
Again, thank you, Carl.